At this time, I'll take up the trial in the case of the State of Idaho versus George Gordon. This is case number 25C-1166. Mr. Carnahan, you represent the state. Are you ready to proceed today?
Yes, we are, Your Honor.
Mr. Gordon, are you ready to proceed today?
No, Your Honor. I have some administrative and procedural matters that I'd like to take up this time.
What are they?
Well, there are a number of jurisdictional defects, Your Honor. I'd like to bring forward this time, one of those being my right to counsel. I have the right to the assistance of counsel guaranteed to me by the Constitution, and I'd like to assert that right. Mr. Hallstrom will be my counsel, and he is in the courtroom, and I would very much like to have him sit here to assist me and help me with my paperwork, and even speak for me when I direct that he should, and such things that are necessary. Also, there's the issue of status, Your Honor. My status being that I'm a free man, not acting in a corporate capacity or quasi-corporate capacity, and therefore not subject to this statute. Let's see. Also, Your Honor, I'd like to know what Mr. Carnahan's authority is for sitting in here. I understand that he is a prosecuting attorney, and I have the right to a public prosecutor, member of the executive branch of government, rather than a judicial officer, as Mr. Carnahan is. Authority is for sitting in here. I understand that he is a prosecuting attorney, and I have the right to a public prosecutor, member of the executive branch of government, rather than a judicial officer, as Mr. Carnahan is. Also, there's a matter of grand jury indictment. This is a felony that's being brought against me, and I have the right to a grand jury indictment, and there has been none at this time, and which is, again, a matter of rights. And then also, Your Honor, Article 3, Section 2 of the Constitution provides that when the state is a party to the action, the U.S. Supreme Court has original jurisdiction. And since the state is a party to the action, I move for dismissal on this above grounds due to the fact that this court does not have jurisdiction. Because of Article 3, Section 2, when the state is a party, the action must come or originate in the U.S. Supreme Court. And so I'd like to move at this time that the...
Your Honor, I object to these specious and frivolous demands made by the defense. We've covered all of these in the preliminary motions, and all of them were denied. Mr. Gordon is obviously trying to disrupt the proceedings here, and as you can see, during jury selection, he was constantly asking questions, just dragging out the proceedings and wasting the court's time. There isn't any merit whatsoever to any of the arguments that have been brought up, and I object to this.
Mr. Carnahan, let me find out if Mr. Gordon is through with his preliminary matters, and then I'll rule. Do you have further preliminary matters?
Well, there are many.
I want to be sure you're heard, but...
there are many other matters that this court has looked at during my motion hearings prior to the trial, and...
do you have further preliminary matters?
I would just like to move the court at this time to accept these motions and dismiss the charges against the defendant.
I think Mr. Carnahan is right. We've heard all these matters in motion hearings prior to trial. I have granted those that have been granted, and those that have been denied are still denied, and so we'll proceed on that basis.
Let the record show, Your Honor, that I do object, and I'd like to lodge a continuing objection to moving forward. As the case, this court does not have jurisdiction.
Your objections have been noted, and with those objections on the record, are you now ready to move forward?
Am I going to be allowed counsel, Your Honor?
that subject has been discussed at a motion hearing, and your counsel has been denied, so that will continue.
Well, let the record show that I object again, Your Honor.
We've noted your objections. With those objections on the record, are you now ready to proceed?
I am not ready to proceed, but in order to protect my life, liberty, and property, I see no other way.
All right, we're assuming then that is a statement that you're ready to proceed. Bailiff, would you bring in the jury, please? Mr. Carnahan, are you now ready with your opening statement?
Yes, Your Honor, I am.
You may proceed.
Well, ladies and gentlemen of the jury, this case is relatively easy, I believe, for the state to put on. And it's my job as the representative of the state of Idaho to enforce the laws of the state of Idaho. And as we discussed when we were talking to you about voir dire, you all promised that you would render a true and correct verdict and that you'd find the defendant guilty. If I could show you and prove to you beyond a reasonable doubt that Mr. Gordon did in fact destroy the jail, he did in fact destroy coveralls, the property of the state of Idaho, willfully and maliciously, and I'm going to show you that today. Now, Mr. Gordon thinks that this is funny and that this is some kind of a game, that he just goes out to the jails and comes into the courts and he plays these games and wastes the taxpayers' money. He constantly brings these frivolous issues into the courts time after time after time. And he gets away with it time after time after time. And we feel at the prosecutor's office that it's time that we showed you that, one, Mr. Gordon went out to the jail after a lawful arrest for not having a driver's license, a registration, and a proof of insurance. Now, all of us have driver's licenses, and we all register our cars, and we all provide insurance on our cars to protect each and every one of us. And we do that because it's the law, and we do it because it's right. But for some reason, Mr. Gordon thinks that he's above the law. And he was arrested and taken to jail. And while he was in the jail, he absolutely refused to be fingerprinted and booked into the jail. He resisted and obstructed a police officer in the performance of his duty. He resisted arrest when he was arrested at the scene of the traffic stop. And then he absolutely refused to wear the assigned jail clothes. Later, when he was taken into the jail cell, he destroyed his jail clothes. He tore them up and absolutely obliterated them. Clothes that you and I and every one of us had to buy and pay for. This man over here willingly and maliciously destroyed. He has absolutely no regard whatsoever for the laws of Idaho or for the property of the state of Idaho. He's constantly outside the law. He's a consistent repeat offender, time after time after time, in traffic case after traffic case. He has been arrested 30 times in the last 5 years. And he's been in the courts, in and out of the courts, and in and out of the jail so many times that for me to sit here and read it all to you would get boring before the afternoon was up. And we think it's time that we brought Mr. Gordon to justice, and that's why we've brought this action against Mr. Gordon. And I'm going to show you conclusively that this one charge, the destruction of jails, is a true and correct charge, that it's a violation of Idaho Code 18-2204, and that Mr. Gordon is guilty of it, and that we have witnesses who will testify as to his guilt and as to exactly what happened. And so, for my first witness, I'd like to call Officer Bruce Honey.
In due course, Mr. Carnahan, first of all, we want to find out if Mr. Gordon has an opening statement, or he may reserve if he wishes.
I would like to reserve my opening statement.
You can reserve your opening statement till later. Now, Mr. Carnahan, if you wish to call your first witness, you may do so.
Our first witness, Your Honor, will be Officer Honey.
Bring Officer Honey.
Mr. Honey, will you please rise? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
You may be seated now, please.
Mr. Honey, would you state your full name and spell your last, please?
My name is Bruce Honey, Honey.
Officer Honey, would you tell us how you're employed?
I am a deputy county sheriff, Ada County.
And how long have you been with the Sheriff's Department, Mr. Honey?
Approximately 4 years.
I want to call your attention to the 9th of April, 1982. Did you have any special assignment at that time?
Well, I worked in the jail at that time, yes.
Now, what shift did you work in the jail at that time, Mr. Honey?
From 6 o'clock in the morning till, I believe it was 2 o'clock in the afternoon.
Now, in the course of your duties, did you have occasion to meet the defendant in this matter, Mr. George Gordon?
Yes, I did.
Would you recognize Mr. Gordon if you were to see him again?
Yes, I would.
Do you see him in the courtroom at this time?
Yes, he is seated as the defendant.
And would you tell us what he's wearing?
He's wearing a white shirt with a bi-striped tie.
Now, by that, do you mean that he's seated at the end of the table that I'm seated at?
Yes.
Your Honor, may the record reflect that Mr. Gordon has been identified.
The record will reflect that the witness has identified Mr. Gordon.
Thank you, Your Honor. Now, Mr. Honey, calling your attention again to the 9th of April of this year, did you have occasion to meet Mr. Gordon on that date?
Yes, I did.
And at approximately what time?
I believe it was about 6:30 in the morning. I was passing out razors to the cells.
And would you describe for us generally what you saw and what happened?
When I came to cell block A, which is a unit that had 10 beds, I noticed that under Mr. Gordon's head was a foam mattress that had been rolled up to be a pillow under his head.
Were you able to determine whether or not the mattress cover came off that particular foam?
Yes, it was the same mattress that they use in those cells.
In other words, that mattress cover goes with that foam, and that makes a complete foam mattress. Is that correct?
That's correct.
Now, were all of the other mattresses in the tank covered with mattress covers?
Yes.
And this is the only foam mattress in the cell that was uncovered?
Yes, it was.
What do you have to do to remove the mattress cover from the mattress?
Well, you just have to cut or strip the seam from the cover. And it'll just slip and pull apart.
Okay, had some of the stitching been removed from that mattress?
They are all used mattresses. I would imagine that some of it was, yes.
And at approximately 6:30, it was not?
It was not.
And this piece of foam from the mattress was underneath Mr. Gordon's head, is that correct?
That's correct.
Well, when you observed this, did you take any action?
He moved the foam mattress and the cover out of the cell, and I noticed that Mr. Gordon was sleeping on 2 cotton mattresses. When I told him, at that time, I told him he'd have to give up one of the mattresses and put it on an empty bed in case somebody else came in.
Okay, but did you have occasion to meet Mr. Gordon or see him later that morning?
Yes, I did. At approximately 8:15 in the morning, I went back to the cell to pull Mr. Gordon and some other gentlemen for traffic court.
What were they going to do?
Well, I was going to take them from the county building to the traffic court for arraignment.
Okay. And what did you observe, if anything, about Mr. Gordon at that time?
Well, when I went to the cell, I called out the names of the people needed to go to the traffic court. He had gotten up and he was dressed in only his socks and underwear and a T-shirt. I told him to get his coveralls on. He would have to go to court with coveralls on.
Well, what, if anything, did he say in response to that?
He just stood there silent. He didn't say anything, just stood by the table in the cell. I then noticed that there was a clump of orange underneath his bunk, which was the coveralls. I leaned underneath the bunk to pick them up, and the coveralls had been torn at the seams, and there were about 11 pieces.
Okay. Were there any other, or approximately how many inmates were in the same cell as Mr. Gordon?
There were 7 other inmates in the cell at that time.
Did any of them not have their coveralls on?
They all had their coveralls on.
Okay, after observing the torn coveralls, what, if anything, did you do?
I immediately placed Mr. Gordon under arrest for destruction of jail property and then escorted him out of the cell down to take him to traffic court. And I advised my supervisors that he had torn the coveralls up.
Did you ever request that he put on other coveralls for his arraignment?
Yeah, we asked him if he would, put on the coveralls to go into court, and he refused.
Did he verbally refuse?
He just would not comply.
Okay, well, did you ever have the occasion to talk to the traffic court judge about this matter?
Yes, we, along with other gentlemen that we took over the traffic court, we escorted Mr. Gordon over in what he had on, which was T-shirt, underwear, and socks. We locked him and the other gentleman in the holding cell there at the traffic court, and I advised Deputy Marshal Riggs that Mr. Gordon was there and that he would not put on his coveralls, at which point Mr. Riggs asked him if he would go back to the jail and put on coveralls for the court, and he refused. And then at that time, Marshal Riggs and myself went to Judge Schmidt's chambers to inform him that Mr. Gordon would not put on the coveralls to make the arraignment in traffic court. Judge Schmidt then asked us if we would go back and ask Mr. Gordon to put on the coveralls to make the arraignment in traffic court, at which time we went back and Marshal Riggs asked Mr. Gordon if he would put on the coveralls for the arraignment, and Mr. Gordon refused.
Did he do that verbally, or how did he refuse?
I'm not sure whether he verbally refused or just stood there silently.
All right. Well, then, prior to this date, have you had any similar incidents with Mr. Gordon?
Yes, I have.
Approximately how long ago?
Approximately 1 or 2 weeks before that date, he had been arrested on traffic charges again, and when I pulled him out for arraignment over at traffic court, he refused to get dressed, at which point Officer Specialist Dillonard, we both physically dressed Mr. Gordon.
Where did the incident that you have just described take place?
Approximately 2 weeks ago.
No, where? Where did it take place?
In the Ada County jail.
Was that on the 9th of April?
Yes, in the Ada County jail.
What will the jail have to do, if anything, to repair the injury done to its coveralls?
We'll either have to have them completely resewn together or just purchase new coveralls.
Okay, thank you. I have no further questions at this time, Your Honor.
Mr. Gordon, do you wish to ask Mr. Honey any questions?
Yes, Your Honor, I do.
Then you may proceed.
Mr. Honey, I'd like to bring your attention back to the very first time that you saw me in the Ada County Jail. That would have been approximately on or about approximately March 26th. Do you recall that event?
Not the specific date, no.
Okay, but you mentioned...
I remember meeting you before.
That was about...
the 9th, yes.
It was about 1 or 2 weeks before, okay? The date was March 26th. Now, on that time, would you relate, please, to the court what happened from the time Officer Noble brought me in, just in general, give us a little background?
I have no knowledge or can't answer your question because I do not recall if Officer Noble brought you in on that day or at what time.
Okay, why don't we bring your time back? What time do you get off work? Are you always off at 2 o'clock?
Most generally, yes.
Okay, so then, do you remember seeing me in the jail during your shift period the following morning, which would have been the 26th?
What date was the 26th? Was that a Wednesday?
Yeah, I was taken to the jail on the 25th at 3:30 in the afternoon, so you weren't on duty then, I would
no.
presume.
No.
But you were on duty the next morning at 6 a.m., is that correct?
Yes, that would have been the Friday, March 26th.
Okay. And you observed at that time that the defendant was not wearing his jail clothes, is that correct?
If you're referring to the date that Officer Dillonard and I dressed you to go to the traffic court, that would be the right date.
Now, did the defendant at all times bring up the subject of his constitutional rights?
I really don't recall if he did or not. It seems to me most of the time he stood silent.
Okay, do you ever remember the statement, I demand all of my rights at all times and waive none of my rights at any time?
You may have. I just don't recall.
But you don't recall. You do recall that the defendant refused to wear his clothes that morning of March 26th, is that correct?
Yes.
How many other defendants have you ever observed who refused to wear his jail clothes?
I'm going to object to that as being irrelevant, Your Honor.
I shall also sustain the objection.
Your Honor, it's not irrelevant. I must insist that it's highly unusual for a person not to wear his jail clothes, and there had to be a reason. The defendant... the witness is claiming that he doesn't remember, but if the defendant claimed his First Amendment rights to freedom of speech, as the jail clothes are certainly a part of that, it's irrelevant to this court to know what is highly unusual for anyone not to wear those jail clothes. But for some reason, this defendant didn't wear those jail clothes. If this defendant didn't wear the jail clothes, there must have been a reason, and that reason is important to me.
Oh, it's irrelevant as to how many people don't wear jail clothes. The objection is sustained.
Okay. Let's ask the question this way then. Have you ever observed that kind of behavior before?
I'm going to object on the same grounds, Your Honor.
The objection is sustained.
Okay, so let's bring you up then to the day of April 8th at about 12:30 to 1 o'clock. You were on duty at that time, weren't you?
Are you talking
April.
early morning?
No, about 12:30.
Noon.
Yeah. April 8th, noontime, 1982. Officer Noble brought me into the jail. Were you on duty at that time?
I wouldn't have been on duty, but whether I was in the jail at that time, I couldn't say. I may have been in court. I'm also a transport officer.
Uh-huh. Were you in the jail at that time?
I cannot truthfully say. I may have been here at the courthouse at that time on that day.
Did you take part in the physical fingerprinting of this defendant either at the first encounter or the second encounter?
I printed you once. I don't know whether it was the first or second time that before the charge of the destruction of jail property. I printed you one time before that. Is that the date you're referring to?
How did you print this defendant? How did you obtain the fingerprints?
I took your hand and printed them.
Okay, and at that time, did you physically pick the defendant up and carry him over to be fingerprinted?
No, I did not.
You did not? Did you get the fingerprint card signed by the defendant?
No, I didn't.
Why didn't the defendant sign the fingerprint card?
You refused to sign the fingerprint card.
Your Honor, I'm going to make an objection at this time, and I think that we need to take a recess out of the presence of the jury so that we can discuss this erratic cross-examination.
We'll take a 10-minute recess.
Thank you, Your Honor.
Court will now come to order, please.
Now that we've decided these procedural matters, you may proceed, Mr. Gordon.
Thank you, Your Honor. Officer Henning, I'll just kind of backtrack just a little bit here and ask you a few questions here again now. You did not, did you get the fingerprint card signed by the defendant?
No, I did not.
Why didn't the defendant sign the fingerprint card?
You refused to sign the card, the fingerprint card.
So at the time I refused to sign the fingerprint card, did this defendant say to you, I demand all of my rights at all times and waive none of them at any time?
No, sir, I don't believe you said that at that time. I believe you just stood silent at that time.
All right. You can't remember. Is that your testimony?
I don't remember. As far as while fingerprinting you, I don't recall you ever saying that.
And you do then admit that you took part in the fingerprinting of this defendant at one occasion. Is that correct?
Yes. Yes.
How many times has this defendant been fingerprinted, to your knowledge, in that jail?
Well, offhand, I would say probably at least twice that I know of. He may have had another time before then.
Okay, would you please tell the court what were those two occasions that you knew of?
Well, the occasion that I took your fingerprints.
Yes.
And I would assume from the felony arrest of the destruction of jail property.
Uh-huh. Okay, now we have 3 events. Is that correct?
It could be. I have no knowledge of the matter of the arrests that you've had.
March 25th, do you remember that arrest?
Let's see, that's the one where you said you came in at 3:30 in the afternoon?
Uh-huh.
Okay, I was not on duty, so I would not have any knowledge of that.
You testified a little earlier that you physically dressed me the morning of the 26th.
Yes, that's got nothing to do with your fingerprints.
Okay, we're not talking.
I don't know if you were printed on that date or not.
Okay, but that's the first event. You know that I was in that jail on March 26th because you physically dressed me. Is that correct?
Yes, sir.
All right, that's what we wanted to know. And the second event occurred April the 8th at 12:30 in the afternoon when you were on duty. Do you know of that event?
Well, I know you was in. I don't recall. I assume that's the day I took your fingerprints.
So we have...
But I'm not positive of that.
April the 8th. Now, the morning of April the 9th, you arrested the defendant in cell number A or cell letter A. Is that correct?
Yes, sir.
At about what time?
That was about 8:15.
8:50?
Approximately 8:15. Quarter after 8.
Oh, approximately 8:15. Quarter after 8, approximately.
Approximately.
Okay, now you testified that at that time that you arrested me, you were on duty until what time that day?
It would have been till 2:30 that afternoon.
2:30 that afternoon. Were you in the jail on that day?
Probably that day in the jail at the courthouse.
Okay. Did you take the fingerprints of the defendant on April the 9th on the felony charge?
No, sir, I don't believe I did.
You did not? Okay. Okay, let me take your attention back a little bit now to the morning of April 9th. You say that at 6 in the morning you walked into the jail cell?
6:30.
6:30. You observed the defendant, George Gordon, asleep on his bed, or is that correct?
Yes.
You observed the defendant sleeping on a mattress. Is that, rolled up mattress foam. Is that correct?
He was sleeping on 2 mattresses with a rolled up foam mattress underneath your head.
Did you observe the defendant destroy the said mattress?
No, I did not.
Okay, I believe you testified that the cover was over under the window. Is that correct?
Yes, sir.
Now, would you describe to the court, please, the condition of the mattress cover?
As I said to the prosecutor, the mattress had been well used before. It was only more than likely torn on some of the seams and had some cigarette burn holes in it. both the mattress and the cover.
Mm-hmm. So the mattress was well used?
Yes, sir.
Well, then, could it have been that the mattress at the time that the defendant was taken to the jail cell was already outside the cover?
That is possible.
Could it have been because you didn't have, of your own knowledge, any information concerning the condition of the mattress prior to 6:30? When you came into the cell, April 9th, is that correct?
Yes, sir.
When did you first notice the little pile of rags under the bed?
That would have been at approximately 8:15.
Okay, so at 6:30 when you came in, the defendant was asleep, but you didn't notice the rags under the bed at that time?
Well, I wasn't looking for any rags or coveralls at that time. While you were sleeping in the bed, you were in your T-shirt.
How many inmates, or how many prisoners were in that room at the time the defendant, George Gordon, was first introduced into that room?
First placed into that cell?
That's correct.
I have no knowledge at that stage how many people were in there in the room in the cell that you were placed in.
So when the defendant first went into the room on April 8th, you were off duty at 2 o'clock, is that correct?
I could have been. I don't know for sure.
But normally you'd be off at 2 o'clock.
Yes, normally.
If the defendant was arrested and brought to jail at 3:30, you wouldn't be there, would you?
Normally speaking, if there was no overtime involved, no, I would not be.
Let me ask you this. Any time after 2 o'clock, April the 3rd, did you go into that cell prior to 6:30 in the morning?
On the 8th?
Excuse me, yes, the 8th. Between 3:30 in the afternoon of April the 8th and 6:30 in the morning on April the 9th, did you enter that cell?
I could have.
You could have, but you don't remember.
I do not remember what hours I worked that day.
Let me ask you this. What hours do you normally work?
Normally I work from 6 a.m. until 2 p.m. That's my regular schedule.
You ever work overtime?
Yes, I do. Approximately maybe 3 to 4 hours a week.
Is that in the jail or is it outside of the jail normally?
Both in the jail and with the court transports.
Could it have been that you went into that cell at some time between 2 o'clock on the 8th and 6:30 in the morning? Could you have?
I could have, yes.
Did you?
I don't recall.
You don't recall. 6:30 in the morning, when you went into the cell, how many people were in that cell?
Besides yourself, there were 7 other people.
So there was a total of 8 persons inside that cell at 6:30 in the morning. Is that right?
Yes.
And at 8:15 in the morning, how many people were in that cell?
I just answered that question. There were 8 people, counting yourself.
At 6:30, there was 8? How many were in the cell at 8:15?
8:15, there were 8.
Okay, so the population of the jail cell didn't increase or decrease between 6:30 and 8:15.
No, sir.
Now let me bring your attention to what you saw. You walked in, you're passing out razor blades, is that correct? Or whatever it is you do at 6:30?
I set in a razor at 6:30 in the morning, yes.
You set a razor down on the table at 6:30 in the morning. Is that it?
Either it was on the table or the first bunk by the door.
And then you left, but you didn't notice the pile of rags under the defendant's bunk.
Not as far as looking at rags, no.
Were the other prisoners up and walking about at 6:30, or were they in their bunks?
As I recall, they were all in their bunks.
When you came in at 8:15, you walked in. What did you say, or what did you do? How did you go about this? You walked in the door, and what did you?
I just walked in the door and would call out any of the names of the people that needed to go to the traffic court that morning.
How many people at 8:15 do you recall standing up and about?
From what I can recall, besides yourself going to traffic court, I believe there was 4 or 5 other people that went to traffic court. I'm not sure of the exact number of people, but...
Were they standing up, or were they getting out of their beds?
They were getting out of their beds, or...
They were getting out of their beds?
Getting out of their beds or standing up.
Okay. I was talking. Let me ask you this question this way. Was the defendant talking to a man by the table when you walked in?
I don't recall if you were or not.
You don't recall. Okay. But you do recall that the defendant was standing there in his underwear. Is that correct?
Yes, sir.
And you testify that everyone else in there was dressed in his jail uniform. Is that correct?
Yes, sir.
Was everyone in there visible to you, or were they under their covers?
From what I recall, the only people either up or about or were getting out of their beds were people that I called for traffic court. I believe there were 2 other people still in their bunk.
You testified that, let me see if I remember this correctly. You tell me. You walked in, I'm standing there in my underwear. Did that appear bizarre or unusual to you?
No, sir.
That's not unusual?
No.
Most prisoners in the jail do not wear their prison uniforms. Is that what you're saying?
As far as sleeping in them, no, sir.
Most of the prisoners in the jail take their uniforms off and sleep in their underwear. Is that what you're saying?
Some do. Some sleep in their coveralls.
Well, about what proportion do?
I don't know. 50-50. It'd vary.
About half and half? Half the people in. Half the inmates are taking their clothes off. Half of them do not. Is that what you're saying?
That's what I'm saying.
Okay, and how long have you been a jailer?
4 years.
4 years. So for 4 years, then, you've been observing this.
Yes, sir.
Now, you walked in. Here's the defendant. He's standing in his underwear. What did you say to him?
I ordered you to get your coveralls on so that we could go to traffic court.
Did the defendant say, "Have you brought my clothes to me"?
I believe he did. I'm not sure of the direct contents of the words.
Okay, let me make the quotation again and then just testify for the record if you would. Did the defendant say to you when you said, "Gordon, get your clothes on," did the defendant say, quote, "Have you brought my clothes to me"?
Objection, Your Honor. That question has been asked and answered.
I don't believe he's answered this question. The objection is overruled.
I believe you did. In regards to your civilian clothes,
That's correct.
I believe you did. but I'm not real positive. It's...
All right. When then, what did you respond? What did you say?
I would have advised you that for the arraignment that you could not wear your civilian clothes, that you would have to go into the arraignment in jail clothes.
Uh-huh. So in any event, you would have overruled my objection had I made an objection.
Yes, sir.
Did I make the objection?
You may have. I don't recall.
But it's pretty obvious that from the previous encounter, you testified that you physically put me into those jail clothes.
Yes, sir.
So would you then deny that I made the objection?
I really can't say. I don't recall if you made the objection or not for sure. To say that you made the statement.
I'll come back to that. Let's go on then to the next event. I'm standing there. We'll assume that I've made the objection, and what did you do then?
I went over to your bunk and picked up the coveralls from underneath your bunk.
You went over to my bunk?
Which was the bed that you were sleeping in.
Now, when you were talking, were you facing my bunk, or did you have your back to my bunk at the time we were talking about? Did you bring my clothes?
I would have had my back to your bunk.
Okay, let's see if I understand this now. You came in, we're talking. I'm standing by the table. You have your back to my bunk, and we're talking, and you say to me, Gordon, get your clothes on. And I replied, have you brought my clothes to me? And then what did you say?
Well, if you had asked that question as far as regards to your civilian clothes, I would have denied it and told you to put on your coveralls.
So then, of your own knowledge, you know that the defendant refused to wear the jail clothes.
Yes, sir.
You know that I refused to wear the jail clothes on the previous encounter with the jail. That was March 26th because you physically put me in there.
Yes, sir.
And on the morning of April 9th, you know that I refused to wear the clothes because I wasn't wearing them. Is that a correct statement?
Well, you was not wearing them, and you did not comply with my order of putting on your coveralls to wear them to court.
So it was pretty obvious that the defendant was not going to wear the jail clothes. Is that correct?
I would say that it was obvious that you would not. I would say that it would be obvious that you was not going to volunteer to wear them.
Then you would have put me into them.
Had they been intact, yes.
Okay, you're standing there and you're talking to me, and did you say, Gordon, have you torn up your jail clothes?
No, I did not.
You did not make that statement?
No, sir.
All right. Let me point out that you're under oath, okay? Now let me ask you that question again, and then you give us the answer. You were standing there with your back to my bunk, and you said to me, Gordon, get your clothes on. I said to you, have you brought my clothes to me?
I'm going to object to this, Your Honor. There's no reason for him to reiterate everything that's been testified prior to asking the next question.
I think it's necessary for clarification. The man has made a statement.
Well, let's go ahead with this. We don't have to go over everything twice here.
I understand, Your Honor. I just want to make sure that this particular point is nailed down.
Okay, go ahead.
Okay, and you said, Gordon, have you torn up your jail clothes? Did you make that statement?
If I understand your question and the way you're asking it, you're asking me that while my back is turned and I ordered you to put on your jail clothes, you refused. I then asked you if you tore up your jail clothes.
That's correct.
No, sir.
You did not say?
No, that is not the way it happened, sir.
Okay, would you tell us how it happened?
After ordering you and your refusal by standing silent or my denial of your civilian clothes, I then turned to find the coveralls, and they were underneath your bunk, at which point I picked them up and noticed that they had been torn apart. Now, at that stage, I then placed him under arrest for destruction of jail property. At no time during the conversation did I ask him if he had torn up his coveralls.
All right. I just want you to be clear on that point on the record. What happened then? What did you do at that point?
At that point, I then picked up the pieces of the coveralls and escorted yourself along with the other gentleman out to the holding cell to get ready for traffic court.
Let me ask you in more detail then of the events that transpired, because there may have been some pertinent things occurring. Let's see. Did you pick up the rags, this pile of rags from under the bed, and then did you come over and say anything to the defendant? Did you ask the defendant, for example, what is this?
No, sir, I did not.
Did you ask the defendant, did you tear up your clothes?
No, sir, I did not.
Did you ask anyone else in the room, where did this pile of rags come from?
I asked one other party in the cell at that point, and he would not answer either way.
Let's see, you're standing there now. You've got this pile of rags in your hand. At what point did you arrest the defendant?
I immediately arrested you after I picked up the pile of coveralls from underneath the bed. I physically walked over and told you you were under arrest for destruction of jail property.
So you walked over. About how far from the table over to this bunk is it?
About as far as from the distance that we're seated.
About 10 feet away, say.
10, 15 feet.
You turned around, went over to the bunk, picked up this pile of clothes, rags, or whatever they are, brought them back, and immediately arrested the defendant. Is that correct?
Yes, sir.
What did you say to the defendant?
I said you're under arrest for destruction of jail property.
And what did the defendant say to you when you said you're under arrest?
As I recall, you sat silent, or stood silent.
Let me refresh your memory. Let's see if maybe this could have occurred. Did the defendant say to you, is this civil or criminal?
I don't recall if you did or not.
I won't reiterate that question. He said he didn't recall. Did the defendant then say to you, I demand counsel present at all stages of this interrogation?
I believe you did something to that effect. And I replied that I wasn't asking you anything. If I remember correctly, something of that nature.
Did the defendant then say, I demand all of my rights at common law and waive none of my rights at any time?
You may have. I don't recall.
You don't recall. A little earlier, though, you testified that I stood silent, but now you don't recall. Did I say anything or did I remain silent?
I can't answer either way. I don't recall if you said that. You may have. I'm not denying that you didn't. I just do not recall if you did. You may have.
Let's go on then with the scenario and let's see if we can follow the story flow through. What did you charge the defendant with verbally?
Destruction of jail property.
Let me ask you this question. Did you say to the defendant, Gordon, you stupid asshole, this is a felony in Idaho, with your hand on the defendant's T-shirt, pushing him up against the wall?
No, sir, I did not.
You did not do that?
No, sir, I did not.
And you did not say that?
I did not say that.
At that point, the defendant's under arrest. Was the charge civil or criminal?
Criminal.
It's criminal. Well, is it a felony or is it a misdemeanor?
Destruction of jail property is a felony.
Okay. Who told you that it was a felony?
That's a statute. That's a code statute. I know it is a felony.
Okay, and you've known that for how long?
Yes, sir. A long time.
Long time. That isn't something that was new, that was told you after the fact, is that correct?
No, sir.
So you knew it was a felony prior to contacting Deborah Carnahan of the prosecutor's office, is that correct?
As I recall, I did not contact her initially. I believe Lieutenant Hope contacted her first.
Did you talk to Deborah Carnahan?
Yes, sir.
So you know it was a felony prior to contacting Donald Carnahan of the prosecutor's office, is that correct?
As I recall, I did not contact him initially. I believe Lieutenant Hope contacted him first.
Did you talk to Donald Carnahan?
Yes, I did.
Did he give you any advice?
Yes, he did.
What was that advice?
That advice was to go ahead and charge you with the felony destruction of jail property.
Okay. Then what happened? Charged me with destruction of jail property. What did the defendant say at that point?
I don't recall at that point. I don't recall any conversation other than taking you over to traffic court.
Let me ask you this. Do you remember the defendant saying, I demand to be taken to a magistrate under Rule 4C?
At that stage, I don't believe you did. I'm not positive, but I don't believe you did.
Could I have?
You could have.
Okay, but you don't remember.
I don't believe you did.
You don't believe I did.
No, sir.
But you don't know that I did not.
Yes, sir.
Okay, so then what happened? We all walked out into the hall, is that what you're saying?
Yes, sir. We walked down to the holding cell.
How many people?
I'm not sure of the exact amount. 4 or 5 people beside yourself.
Several?
Yes, sir.
Okay, we went down the hall. Did you ever demand that the defendant wear jail clothes?
Well, the clothes that were in the cell, and you refused to put them on, but they were torn, so you couldn't. And as I recall, you refused. That's the reason we took you to traffic court in your underwear.
Did you attempt to dress the defendant in any other type of clothing?
No, sir, I did not.
So you took the defendant down the hall and into a holding cell, is that correct?
Yes, sir.
And he was in the holding cell while you talked to Judge Schmidt, is that correct?
Yes, sir.
Did you talk to Judge Schmidt?
Yes, sir.
And you talked to Marshal Riggs?
Marshal Riggs was with me when
you went in to talk to the judge?
Yes.
Did the defendant appear in court that morning in his underwear?
To the best of my knowledge, you did.
You weren't there?
I was not present in the courtroom, no, sir.
Well, when did this involvement terminate?
Well, it terminated after the Marshal Riggs, after talking to Judge Schmidt. Myself and Marshal Riggs came back to the holding cell. Marshal Riggs informed you that Judge Schmidt requested that you wear the clothes provided by the jail for arraignment, at which time you stood silent.
You stand there before this defendant and observe him in the holding cell naked?
Naked? No, sir.
Did you observe the defendant dressed in his underwear in the holding cell?
Yes, sir.
When did you leave? If you weren't in the courtroom, you left. And want to know where hearsay...
Immediately after Marshal Riggs had informed you that, of the request of Judge Schmidt, at that point or some minutes later, I had gone back to the jail.
So then you do know then, of your own knowledge, that the defendant did not put on any other clothes?
Yes, sir.
Do you know of any other times when you took a defendant to court not dressed in jail clothes?
Objection, irrelevant.
The objection is sustained.
Okay. Let me ask the question like this then. You do know that the defendant appeared in court without jail clothes?
Yes, sir.
Now, on March 26th, when the defendant refused to put on his clothes, you forcibly dressed the defendant. Is that your statement?
Yes, sir.
Why didn't you forcibly dress the defendant on April the 9th?
I was under orders of my lieutenant.
The lieutenant, what was the motivation behind not dressing the defendant forcibly on April the 9th?
In regards as to the order of the lieutenant, I have no knowledge of why he did not.
Did you discuss with him any motive?
No, sir, I did not.
Did anyone say to you that if he appears in his underwear, they'll hold him in contempt of court?
No, sir, I don't know what a judge is going to do.
Okay, so you don't know what the motivation for taking the defendant in his underwear to court was of your own knowledge. Is that what you're saying?
No, sir.
Okay. Was it, or could it have been that you were trying to get the defendant held for contempt of court?
No, sir.
Oh, after the event was over in Judge Smith's court, I guess the defendant was brought back to jail. Is that true? Correct?
That would be the standard procedure, yes.
Okay, so the defendant's brought back. What happened next?
I have no knowledge of anything after you come back from traffic court.
You had no further contact with the defendant after the arraignment in Judge Smith's court?
The only contact I had with you after you were arraigned in the traffic court was when I showed you a rights form and asked you if you wanted to be represented by counsel. If you wanted to talk to me, the standard rights form, of which you refused on all of the rights.
Where did this meeting take place?
That took place in the maximum security cell in our juvenile or young offenders side of the jail.
The defendant was held in maximum security?
Yes, sir.
Is that also known as solitary confinement?
In a sense.
In solitary confinement, was the defendant in the jail because he was convicted of a crime?
I have, other than the traffic that you were arrested for and this felony arrest, as far as I know, is the only reasons you were being held in the jail.
Why was the defendant in the jail to start with?
Just for the traffic arrest that I
What was the...
know of. I have no knowledge of the background of the reasons for the arrest.
What was the traffic charge?
I'm going to object to this unless he lays some foundation that the officer, has some personal knowledge of the nature of the offenses and the charges. This is irrelevant.
If the officer doesn't know, he can say he doesn't know.
I am not sure of all the charges. I believe there was 4 or 5 charges, but I'm not positive.
Okay, then your answer is you don't know.
No.
Okay, go ahead, Mr. Gordon.
So you don't know why the defendant was in jail. He was just there.
Yes, sir.
Okay, as far as you know, just there?
Yes.
Let me bring your attention back to March 26th. Do you know why the defendant was in jail at that time?
As far as the initial charge for the arrest, no, sir.
Okay, he was just there.
Yes, sir.
How was the defendant dressed?
I really don't recall, sir.
You don't recall?
No.
On April the 8th, in other words, you never saw the defendant when he was brought into jail. Is that what you're saying?
On March 26th?
Yeah.
I'm not... What time did you come? I don't recall what you were wearing when you were brought into jail.
Let me go on just a little step further then. You were present on April the 8th when the defendant was brought into jail. What was...
I could have been.
You could have been. You fingerprinted the defendant that day.
That is possible.
Well, when you fingerprinted him, he was brought in, and when he was brought in, he was wearing something. You don't remember what he was wearing?
I do not recall what you were wearing, whether what you were wearing a suit or Levi's or...
Was the defendant clean shaven?
Objection, Your Honor. That's irrelevant and immaterial.
The objection is sustained.
Well, I don't think that that's irrelevant, Your Honor. It has to do with...
Mr. Gordon, I have sustained the objection.
Okay, let me bring your attention back to the jail scene in this room. You came in at 6:30, and you testified that there was a mattress cover over under the window. But you didn't see the defendant tear it up. Is that correct?
That's correct.
Objection. This has been asked and answered before.
I agree.
Recapitulation, Your Honor.
Mr. Gordon, we can recapitulate all day. The objection is sustained. Let's don't go over ground we've already been over before.
The point is, Your Honor, that this defendant can't remember about 90% of the events that took place leading up to this arrest.
I realize that, Mr. Gordon.
Okay.
But you don't have to...
Do you understand, then, that
listening to everything what you're saying.
Okay. Let me bring you back to the solitary confinement. You came into a room that's solitary. Is that your testimony?
Well, it's a max cell.
Maximum security?
Mm-hmm.
Okay. What was the reason for putting this defendant in maximum security?
Objection. Irrelevant.
That might not be. The objection is overruled. If you know the answer, Mr. Honey, if you don't know, you can say you don't know.
I will presume it would be on the orders of the lieutenant or the ship supervisor.
Well, either you know or you don't know.
I do not know.
But I was in there.
Yes, sir.
To your knowledge, was I convicted of any crime?
To my knowledge, I have no knowledge of any convictions or no convictions.
So you don't know?
No, sir.
Did I sign anything in that jail to your knowledge?
No, sir.
Did I consistently refuse to sign anything?
Yes, sir.
Did I consistently demand counsel?
Yes, sir, you did.
Did you ever give me counsel?
In regards to the booking process,
Any time did this defendant have counsel?
to my knowledge, no.
At any time was this defendant allowed a phone call to obtain counsel or to secure any kind of help whatsoever?
To my knowledge, no phone calls were allowed.
And how long was the defendant in jail?
On this destruction of jail property,
Yeah.
where it's a felony charge with no bond, it would have been from a total of, from the arrest on the 8th until Monday's arraignment, it shouldn't have been.
What time was the arraignment on Monday?
That would have been 2:30 in the afternoon on Monday.
Were you there at the arraignment?
I do not recall if I was in jail or not. That would have been after my hours.
In any event, the defendant was in jail for 5 days that you know of. Is that correct?
Yes, sir, counting the 8th.
Mr. Gordon, how much longer do you expect to question here? Are you about through? The reason I'm asking is 5 o'clock and it's time for recess. And if you're just about through, we'll continue. But if you have more to go, we'll recess till tomorrow.
Well, I've got quite a few more questions I'd like to ask, Your Honors.
Then the court will stand in recess until tomorrow morning at 10 o'clock.
I agree, Your Honor.
Court is now in session. The jury has been seated. Mr. Honey has been testifying as to the length of time Mr. Gordon spent in jail. Mr. Carnahan, is the state ready to proceed?
Yes, the state's ready to proceed, Your Honor.
Mr. Gordon, are you ready to proceed?
Yes, Your Honor.
You may continue your questioning.
Thank you, Your Honor. Officer Honey, we were just calling here. Let's see. The last question I asked you was, the defendant was in jail for 5 days that you know of. Was that correct?
That's correct. That was counting April the 8th.
And in that period of time, did the defendant ever ask you, quote, will you get me a paper and pencil so that I can write a writ of habeas corpus?
Yes, sir.
Did you ever get the defendant a paper and pencil?
No, sir, I did not.
So the defendant was in jail for 5 days, and you know then, of your own knowledge, that the defendant asked you for counsel and you didn't help him secure counsel. Is that essentially correct?
As I recall, you just asked for a phone call. You didn't ask or explain whether you wanted counsel or what you wanted to do with your phone call.
Did the defendant say, quote, I demand counsel before I answer any questions and before any interrogation continues?
Yes, sir.
So you do remember then that the defendant demanded counsel?
Yes, sir.
What did you do to help the defendant secure counsel?
Go ahead and answer, Mr. Honey.
Would you go ahead and ask that question again, please?
What did you do to help the defendant secure counsel?
Well, I'm going to object to this. All of this is irrelevant to the charge at hand.
Objection is overruled. I think possibly it has some bearing.
All right, Officer Honey, go ahead and answer.
Would you ask that question again, please?
Okay. What did you do to help the defendant secure counsel?
In regards to the rights form?
In regards to any encounter you had with the defendant?
I can only answer in regards to the rights form that where I did not ask you any questions or pursue it any further.
Okay, looking at this rights form here, I would assume, should the defendant have a right to look at this? Your Honor, does he have a copy?
I'm familiar with it.
You're familiar with it. It says here, you have the right to talk to a lawyer and have him present with you while you're being questioned. Did you ask the defendant to initial that line?
Yes, I did.
Did the defendant initial that line?
No, you refused.
In other words, the county jail, let me see if I understand this. The county jail is saying I have a right to talk to a lawyer and to have him present with me while you're being questioned.
Yes, sir.
Did you ask me the question, are you going to initial number 3?
I asked you if you would initial all of the questions on there in regards to that you understood the question, and you refused.
So your testimony is that I refused, but your testimony is that you never helped me get this counsel. Is that correct?
Yes, sir, in regards that I never asked you any questions.
So you're asking me if I'll sign this, telling me that I have a right to a lawyer, but you never helped me get a lawyer. Is that correct?
It says you have a right to a lawyer to be present during questioning. I did not question you.
Well, then is the position to your knowledge of the jail, is it the procedure there that a person can be locked up for 5 days without lawyer or without counsel, without a phone call at all?
On occasion it has happened, yes.
Did it occur in this case?
To the best of my knowledge, no.
Now, wait a minute.
In regards to over the weekend, I do not work the weekend, so I don't know what happened on the weekend.
Mm-hmm. But you do know that you did nothing to help the defendant secure a pencil and paper to write a writ of habeas corpus.
Yes, sir.
Would you tell the court why?
I do not recall if at the time that I read this rights form to Mr. Gordon, I was off duty, and I'm not sure if it had been passed on to the relieving shift that Mr. Gordon request pencil and paper. But I do know that I did not give a pencil or paper.
Did you talk to anybody about bringing me a pencil and paper?
I believe I did talk to the oncoming shift, but as to which officer I talked to, I don't recall.
Mr. Honey, may I point out that you believe and you don't know? Now, would you...
Objection, Your Honor. I'm going to object to this because it's not a question. It's Mr. Gordon testifying. If he wants to testify, let him take the stand and be sworn.
I agree. The objection is sustained.
Okay, let's get back to this particular issue here. The defendant then is in the maximum security cell. You came into the maximum security cell and you have this rights form and you wanted the defendant to initial this. Is that correct?
I read it to you so that you would understand the rights that are on that form and to initial if you understood those rights, at which point you refused to initial on all of the rights on that form.
Did the defendant say, I demand all of my rights at common law and waive none of my rights at any time, and I specifically demand my right to counsel and be taken to a magistrate immediately?
As I recall, the first question on the sheet, you may have stated that, and for the remainder of the rights on the sheet, you stood silent.
Okay, then of your own knowledge, you know then that the defendant stood on his constitutional rights, demanded all of his rights, waived none of his rights at any time, and specifically demanded his right to counsel.
In your own mind, yes.
Not in my mind. What about your mind? What do you know?
In regards to that form,
Now, in regards to my statement, did I say to you, sir, I demand all of my rights at common law. I waive none of my rights.
I believe you did on the first rights question on that form, and then you stood silent on the rest of them. And I believe I also explained to you that only applied if you were questioned, at which point I did not question you.
Well, if it only applied if I were questioned, then it's your testimony that you came in to question me?
I come in to see if you wanted to discuss the nature of the incident, but I did not ask you about the incident. I read you the rights form first.
When did this arrest take place for this felony charge?
At approximately 8:15 on the morning of the 9th.
Did the defendant demand of you then, quote, I demand to be taken to a magistrate immediately under Rule 4C?
You may have.
May. When did the defendant first see a magistrate concerning this felony?
That would have been approximately 2:30 the afternoon.
That's when it's scheduled at 2:30?
That would have been the 12th according to the court schedule.
At 8:15 in the morning, then, was the arrest for the felony, is that correct?
Yes, sir.
Okay, and there were courts available all day. Why wasn't the defendant taken to a magistrate?
According to the jail procedure and the procedures set with the courts and the prosecutor's office, the time for filing complaints and reports That was too late to make the court date for that day on the 9th.
By your procedure?
By our procedure.
What about Idaho statute?
I'm not familiar with the statute quoted.
Okay, you're only familiar with the jail procedure.
Yes, sir.
Not Idaho statute?
Yes, sir.
Okay. After the defendant was taken to the maximum security cell, did you interview any other witnesses concerning this event?
After you were taken to the max cell?
Yeah.
I believe prior, while you were at the traffic court.
And you testified that there was about 7 other people in the cell. Did you question any of the other seven people in the cell?
I only asked 2 about the incident.
You only asked 2?
Yes, sir.
What about the other 5 men that were in the jail?
I did not ask them.
Okay. Could they have torn up the mattress?
They could have.
Could they have torn up the jail clothes?
In regards to the jail clothes, I would say highly unlikely.
Did you ask anybody if they tore them up?
I asked 2 people if you had torn up the jail clothes.
But there was 5 other men in the cell.
Yes, sir.
Did you ask the other 5 men, did you tear Gordon's jail clothes up?
No, sir.
You didn't ask them? The 2 men that you did ask, what did they say?
One replied that he didn't want to get involved. The other replied that you had torn both the mattress or pulled the cover off and tore up the jail clothes.
Let me ask you this then. On this form that I see here, this is your statement, I believe, on April 9th, 1982 at 6:30 hours RO. Who is RO?
That's the reporting officer.
You're the reporting officer?
Yes, sir.
Okay. Was passing out razors to in the cells to the cells in Ada County Jail. The reporting officer then noticed there was a mattress cover under the window in cell A.
Yes, sir.
Okay. There's the mattress cover. What did these 2 witnesses that you did interview, what did they tell you about the mattress cover?
Well, the one witness, or the one gentleman that I asked to, did not want to get involved. The other gentleman, if I recall his statement, said that at approximately 8 o'clock the evening before, you had pulled the cover off the mattress and had torn up your coveralls.
I did that at 8 o'clock the night before? That's his statement?
As I can recall his statement, I believe that was the hours.
Okay. He told you that these events occurred. When did he tell you that?
I believe it was approximately noon. May have been 20 after or so. Approximately in that time area somewhere. It's the time that is on the witness's statement.
Is his name Robert Lay?
Yes, sir.
What was Mr. Lay doing in that cell?
He had been incarcerated on charges.
Is he a convicted criminal? Is he convicted in there?
I have no knowledge of his prior record, if any.
Could he have made this statement hoping to get some kind of concessions from the jail for making these statements as a false witness?
No, sir.
He couldn't?
No, sir.
Why couldn't he?
If you're asking if some kind of deal was made, no, sir. I just asked him if he would sign a witness statement.
Okay. So this one witness out of 7 would sign a statement, but you didn't even ask 5 of the 7 people in there if they did it. Is that correct?
If they did it, no, sir.
And I believe you said that any of those people in there could have done it. Is that correct?
In regards to the mattress, yes, they could have.
How about in regards to the jail clothes?
In regards to the jail clothes, as far as you're referring to maybe a scuffle with one of them?
No, wait a minute. We've got 7 people in the cell. You arrived on the scene at 6:30 in the morning. You weren't there between 2 and 6:30 in the morning, and you've got 7 people in there when you arrived on the scene. Is that correct?
Yes, sir.
You come in on the scene, and you notice that the jail clothes are torn up. What led you to the conclusion that they had been torn up by somebody in that cell?
Well, the fact that all the other gentlemen in the cell were still wearing their coveralls, and you were the only party not wearing coveralls.
So your conclusion is that because I'm not wearing the coveralls, I tore them up?
Yes, sir.
That's a conclusion. Is that correct?
I would assume so, yes, sir.
a conclusion because you testified you didn't see me tear them up.
Yes, sir.
Okay, and you also said you didn't ask anybody else if they had torn them up.
Yes, sir.
I'm going to object to all of this. This line of questioning, and it's all going over the same stuff we've already gone over at least 3 times before.
I agree. The objection is sustained. You've been over this 2 or 3 times, Mr. Gordon.
Okay. Well, let me go on then with this and see if I understand the statement. You observed the suspect Gordon asleep on his bunk. Is that correct?
Yes, sir.
So at 6:30 in the morning, Gordon was asleep.
Yes, sir.
Could someone else have come into that cell in the middle of the night and substituted the suit for the pile of rags that were there?
That is highly unlikely, sir.
It's highly unlikely. I said, could somebody have come into that cell?
I suppose in probability someone could.
Someone who has a key coming in and out. Do jailers go in and out of those cells all night long?
No, sir.
They don't?
No, sir.
Go in and out of those cells. What time do they stop going in and out of those cells?
The only time a jailer may come to the door after midnight would be to put a new commitment into the cell. In regards to our bed checks, they are made through the window, through the hall, or from the hallway. They are not to enter the cell.
How many people were in the cell on April the 8th at, say, 8 o'clock in the evening?
I have no idea of the number of people. I was not on.
You don't know how many people were in at that time?
No, sir.
Many people could have been put in after 8 o'clock then.
Yes, sir.
That's possible.
Yes, sir.
Okay, so you observed the defendant sleeping on the foam rubber. Was the foam rubber destroyed in any way?
You were sleeping with the foam rubber underneath your head like a pillow, and no, the foam rubber, as far as being torn, it is all intact except for a few, like, cigarette burn marks on the mattress.
So the foam rubber mattress is outside of its cover, but it's not destroyed, and it's not torn up or ruined or anything like that?
No, sir.
Okay, so the defendant then was sleeping on the mattress, using it as a pillow, missing the mattress cover. R.O. then pulled out the foam mattress and the mattress cover. That is, you took it away from me.
Yes, sir.
Why did you do that?
Because jail policy is we only have 1 mattress per person in the jail. We allow them no pillows. The other mattresses are there for other people when they unfortunately have to stay in jail.
Okay. Well, was the defendant ruining this mattress by sleeping on it or anything like that?
Generally speaking, I would say as far as the foam mattress goes, no.
Okay. Did you then take it away from the defendant as a kind of summary punishment, like, I'm going to let you...
Objection, Your Honor. He's already testified as to why he took it away.
You did?
You did?
Well, I think that the question is argumentative anyway.
Yes, I believe it is.
So the objection is sustained.
So then at 8:15, you went to cell A to pull suspect Gordon out of the traffic court and observed that I was wearing the T-shirt.
Right.
Under shorts and socks. R.O. ordered suspect Gordon to dress for court. Suspect Gordon did not reply, only just stood by the table in the cell.
Yes, sir.
R.O. noticed a pair of orange gel coveralls under Gordon's bunk. When you checked, the coveralls were found.
I'm going to object to all of this, too. This doesn't in any way get to the issues at hand. He seems to be asking leading questions.
It is.
It's just like him reading the report.
It is.
These aren't questions. This is reading the report. If he has a question to ask, let him ask the question in a proper form. The form of the questions that he's asking are not in the form of a question. They're in the form of a statement.
Go ahead, Mr. Gordon.
I need to have a little background understanding. It says that they're ripped apart at the seams, all right? Now we come to the key issue here. Is the fabric ripped and torn?
The fabric? No. As far as a tear in the fabric, there's where the fabric has been cut up is to a pattern. It's just unsewn.
Okay, it's unsewn?
Yes.
But the fabric itself isn't damaged. It isn't torn and ripped, etc.
As far as the fabric itself, in that manner of speaking, no.
Okay. Now, these jail uniforms, these coveralls, are pretty strong material, wouldn't you say?
Yes, sir.
Have you tried to rip one of those up?
No, sir, I have not.
Do you think you could?
Probably.
What kind of tools or equipment or implements would you need to rip one of those up?
I would say probably only my hands.
You think you could do it with only your hands?
Yes, sir.
How many pieces are there in one of those jail suits?
I do not know the exact amount of pieces to make that suit. I know there are 11 pieces.
Okay, so there are 11 pieces in that jail suit, is that correct?
Well, I would assume so.
How do you know there's 11 there?
Well, I know there's 11 pieces that were taken as evidence, but as far as how many it takes to make the suit, I would only assume 11. I do not know the exact amount of pattern pieces needed to make that suit.
So there are 11 pieces now that you have.
Yes, sir.
Okay, are they here in the courtroom now?
No, sir.
Why aren't they here in the courtroom now?
They're in the evidence room.
We don't have them here now?
No, sir.
Did you have occasion to look at those 11 pieces today?
Yes, I did.
Okay. Was I there when we looked at them?
Yes, sir. You were.
Did you notice that the thread, as they were ripped apart, did you notice any thread in any of the holes?
Oh, there are thread strands hanging from where it was sewn together. Yes, sir.
Okay, so they were they've been ripped then, and there's thread. You can tell well. Tell where the thread is ripped apart. Is that what you're saying?
Well, where the seam was, yes, sir.
So it appears then that, let's see now, you've got a seam right here, and they're stitched right here, and if you ripped it apart like this, the fabric's not torn, but the thread is torn, and the thread is the evidence that it was ripped apart. Is that correct?
Yes, sir.
Did you say to the defendant when you arrested him that this was a felony?
No, sir, I did not.
Okay, so you did not inform the defendant in the jail cell right at the time that you knew that this was a felony, and that you're...
No, sir, I just said that you were under arrest for destruction of jail property.
I see. Now, I don't have any further questions of this witness at this time, but I may want to recall him after we talk to Mr. DeLeonard.
Carnahan, would you call your next witness?
Thank you, Your Honor. I'd like to call Officer DeLeonard next.
Will you please rise? Raise your right hand. Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, I do.
You may be seated, please.
Officer DeLeonard, I want to call your attention to the 9th of April. I guess before I begin there, would you state your name for the record and spell it, please?
I'm Officer D. Leonard. That's D-E-L-E-O-N-A-R-D.
Thank you. And would you tell us what your occupation is?
I'm a deputy sheriff for the Ada County Sheriff's Office.
And how long have you done that type of work, Mr.
About 12 years now.
Mr. DeLeonard, calling your attention to the 9th of April, 1982, were you working at the jail at that time?
Yes, I was.
You were the jailer on duty? A jailer on duty at that time?
Yes, I was.
Did you meet Mr. Gordon at that time?
I did.
Would you recognize Mr. Gordon if you were to see him again?
Yes, I would. He's the gentleman sitting. He's right over there. He's got the striped shirt on and tan pants and lavender-colored tie, or it's purple.
Okay, well, Would the court let the record show that Officer DeLeonard has identified Mr. Gordon? Did you try to book the defendant on that day, Mr. DeLeonard?
Yeah, I did try to book him.
Is that when he returned from court?
Yes.
Well, did you try to book him?
Yeah, I did.
And in what way did you try to book him?
Well, he was refusing to be booked by the other officers. At that time, I advised him that on the orders of the sheriff of Ada County that he would be booked by statute if he resisted, and we'd meet his resistance with whatever force needed to book him. I also advised him that he could be charged with resisting arrest. He could be charged with resisting arrest at that time.
Excuse me. Did you ask him the questions on the booking sheet for the information that you needed to book him?
That was after the fingerprinting in the picture.
Did you ask him the questions that are on the booking sheet?
Yes, I did.
Did he answer those questions?
He refused to. He stood mute.
Did you ask him to be fingerprinted?
I asked him to be fingerprinted.
And how did he respond to that?
He refused.
Well, did you fingerprint, or after he refused to be fingerprinted, did you go ahead and fingerprint him anyway?
I did.
And how did you accomplish that?
Oh, there was a little force that had to be used. I advised him that a mere push, if he was out to...
Okay, but how did you accomplish it, though?
Well, just a matter of pushing him towards the fingerprint stand and took his hands and physically fingerprinted him.
Was he cooperating with you at that time?
Not really.
And did all of this occur in the Ada County Jail on the 9th of April, 1982?
Yeah, it did.
And is that in Ada County?
Yes, it is.
I don't believe I have any further questions, Your Honor.
Mr. Gordon, you may cross-examine Mr. DeLeonard.
Thank you. Mr. DeLeonard, let me bring your attention. Are we talking about April 8th?
No, sir, that would be the 9th.
It was on the 9th.
Yes, sir.
What is your shift duty, Mr. DeLeonard?
I'm on duty at 6 o'clock in the morning until 2 in the afternoon.
Same 6 o'clock to 2 o'clock in the afternoon, is that right?
That's correct, sir.
Okay. So let me ask you, what was the reason that the defendant refused to be booked?
He didn't really give reasons.
Did the defendant ever say to you that it's a violation of my 4th and 5th Amendment rights to submit to this booking without objection?
Well, I don't know if it was in those words, but there was some sort of legal jargon of some type mentioned at that time.
Okay. So what you're saying is you didn't understand what I was telling you, but if I had said, let me see if I can refresh your memory. If I had said I cannot submit to this to this booking procedure because I'm not convicted of any crime, do you remember that?
Not specifically those words, sir.
Do you remember me ever saying, I demand all of my rights at all times and I waive none of my rights at any time?
I do recall you saying that, sir.
And did I tell you that voluntary submission is tantamount to failure to object?
No, sir, I don't recall that at all.
You don't remember that?
No.
Do you remember me saying that failure to object is fatal?
I don't recall that either, sir.
Could I have said that?
Well, like I say, there was some legal jargon at that time, some legal phrases or something like that, but for the most part, I think we covered the first one right there.
Okay. Now we're talking about the morning of April the 9th. Is this correct?
This is correct, sir.
You're trying to book me on the charge of a felony. Is that correct?
That's correct, sir.
Okay. How many other people were present in the jail? Excuse me. How many other officers were present during this period of this attempted booking?
3.
Can you tell us who those people were for the record?
Sergeant Knight, Officer Scarborough, and I believe the other one was Officer Bert Dickover.
Right. Now, I assume that it's your police practice to book everyone that's brought in there. Is that correct?
By statute, yes, sir.
Okay. What is that statute?
That the sheriff should obtain fingerprints, picture, and bookings on all bookings.
What statute is that?
I couldn't quote you with any of the statutes, sir.
So you don't know of your own knowledge that...
Well, I've read it.
You have read the statute?
I've read it.
But you don't know where it is?
No, sir, I don't.
Well, then, you have the defendant here demanding some kind of rights. Is that correct?
From what you, well, the statement that you made, yes, sir.
You heard some legal jargon that you didn't understand.
Yes, sir. It wasn't that I didn't understood. I think I understood.
Okay. Well, then, did you understand at the time that the Constitution supersedes statutes?
I'm going to object to this as being irrelevant, outside the scope of this witness's knowledge.
It's a legal question, Mr. Gordon. You need to ask him factual questions. Mr. DeLeonard is a police officer.
I don't think this is... Okay, I can understand that question, Your Honor. Let me rephrase it. Did the defendant then tell you of his constitutional rights?
I'm going to object to that as being irrelevant.
He knows whether I told him or not.
I think so, too. The objection is overruled.
Did I tell you of my constitutional rights?
All I can remember or recall, sir, was that one statement you made. You mentioned, just aforementioned here.
How many encounters have you had with this defendant in the Ada County Jail?
2, I believe.
Twice? Only twice?
Only twice that I can recall, sir. Yes, sir.
You don't remember 3? Let me ask you this.
No, it's not that I don't remember.
Let me take your memory back here a little bit. You say you were on duty from 6 in the morning until 2 in the afternoon. Is that correct?
That's correct, sir.
Okay. Then were you on duty between 6 and 2 on March 26, 1982?
I probably was, sir. I would. Well, I'm sure it would be.
Okay.
I'm sure it would be.
Did you hear anything? Did anybody tell you about the booking procedure that occurred at 3:30 in the afternoon of March 25th?
Well, I had heard that you were booked, sir, forcibly booked.
Did you hear, did anybody tell you the defendant was unconscious when he was, or when he was fingerprinted?
No, sir, I never heard that you were unconscious. No, sir.
How many officers did you, or did anybody tell you how many officers were involved in that booking process?
I can't honestly say that, sir. I know I heard that our sheriff was involved.
Okay, so you heard then that the sheriff was present at that booking process?
I did, sir.
And that there was at least 2 or 3 other officers there, is that correct?
I can't honestly say, sir.
You don't know?
No, sir, to my knowledge, I wasn't there. I don't really, I got a second-hand story about that the sheriff was there.
That's right. We'll take your hearsay.
No, we won't.
Are you objecting, Mr. Carnahan?
Yes, Judge. I think that all of this is in regard to the prior incident of March the 26th with regard to this witness is outside the scope of direct examination. It's irrelevant to this charge, and it's nothing that Mr. DeLeonard has personal knowledge of, and he's already testified to that.
If hearsay is objected to, it'll be sustained.
I understand.
And also, I would also sustain that on the grounds that this is alleged on the 9th of April, 1982. Unless you're trying to show some prejudice or bias on the part of Officer DeLeonard, then something that happened prior to that would be irrelevant.
I'm attempting to do that, but let me move up to April 9th, and then we'll move back, and then it will be relevant. Let's move up then to April the 9th. You were on duty on April the 8th when the defendant was brought in.
I'm sure I was, sir.
Okay. Do you remember the officer, Boise policeman, bringing the defendant in?
No, sir, I can't honestly say that I do.
Well, what is your function out there at the jail? Aren't you always there around the booking area?
No, sir.
What else do you do?
Well, I'm a control officer. I'm one of the supervisors, and I'm in control most of the time.
Did you attempt to book the defendant on April the 8th?
No, sir.
You didn't?
No, sir.
So the only time you attempted to book the defendant was April the 9th at about 10 o'clock in the morning, would you say?
That's incorrect, sir.
About what time was it?
Well, it was another occasion when you were in the jail. I attempted to book you.
I asked you that, and you said that there wasn't.
I don't believe I did, sir. If we check the tape, I don't think there was a statement that you asked me if I'd ever attempted to book you before. I had taken prints off you. I think I told you on 2 occasions, or I had.
Well, what?
Well, I had booked. I'd been involved in 2 occasions with you.
Okay.
I readily admit that.
Let me ask you this then. Did the defendant cooperate with you?
Well, not fully, sir. The first time you did.
The first time I did?
Well, let me...
Well, then, let me ask you this. What were the differences between the first time and the second?
I'm going to object to that as not being relevant, Your Honor.
I agree. The objection is sustained.
Well, then let me move back then. The time that the time frame we're speaking of right now, April 8th and April 9th, there's 2 bookings. Is that correct?
I don't know, as there was a booking. You were originally brought in. What they could accomplish was considered a partial booking on the 8th, yes.
Well, what is the policy of the jail? Every time you're charged with a crime, are you booked or not?
Yes, sir.
Every time?
Yes, sir.
No exceptions?
No exceptions, sir.
Okay. So if I was brought in April the 8th, I must have been booked.
Unless they had a partial booking.
Okay, partial booking. Would you explain what a partial booking is?
You would not answer any questions, sir. You would not cooperate as far as the fingerprints.
Let's move up to April the 9th. Here we are at April the 9th. What time did you attempt this booking procedure?
It was on your return from the traffic court, about 8:20 or 8:30.
So, 8:30, 9 o'clock? Tell us what happened.
Well, you'd refused to book with several of the other officers. I don't know specifically which one. I advised you at that time that you would be charged with resisting and obstructing an officer, and the reason would be because you would not comply with the booking procedure.
Now, did you agree to testify on behalf of the defendant in the event that we went to court?
I did, sir.
Okay, and what did you agree to testify to?
I agreed that I would testify that you did resist by a mere push.
Why did the defendant, for what reason, did the defendant tell you the reason that he would not comply voluntarily?
I think it was that same aforementioned statement again, sir.
Pardon?
That's the only thing I can recall was that one statement that you made. I can't specifically tell you just what the words were. If you were to go through it again, I'm sure I could.
Your Honor, I'm going to object to this line of questioning about the booking procedure. It's totally irrelevant and immaterial, and I'd like to call a 5-minute recess, Your Honor, to discuss this outside the presence of the jury.
All right, we'll take a recess of 5 minutes.
Thank you, Your Honor. Now let's keep in mind what we're watching here, because we're watching direct and cross-examination of the prosecuting attorney. The prosecutor here is going over the dialogue that he's attempting to show the jury are the factual events and the proofs and the testimony that he's going to convict Mr. Gordon with. Mr. Gordon is laying the foundation as he goes through with this cross-examination. And if you'll notice, this is the entirety of the transcript of a preliminary hearing in Lesson 9. Now, as we read through this dialogue, I want you to follow through carefully and get firmly in your mind what's happening and what questions are being asked. Because if this case had actually gone to trial, Mr. Gordon, the defendant, would have gone through that preliminary hearing carefully going over the same questions that he had asked the state's 2-star witnesses. And every time there was a discrepancy, he would have made an asterisk by that. And he would have asked questions like, are you changing your testimony now from the preliminary hearing, Mr. DeLeonard? Are you changing your testimony now, Mr. Honey? And as he goes through this dialogue, it's necessary and imperative for him to put a little X by each lie, each untruth, because remember, it was Defendant Gordon who was right there in the jail cell, and it was Defendant Gordon that knew precisely and exactly what was said and who said it. And that's why that competent pro se is so much better prepared and qualified to present this case in his own behalf than it would be if he had hired a lawyer, because the lawyer can only know what the defendant tells him. So as we change tapes now and go on to Lesson 26, let's keep this in mind as we go on with Officer DeLeonard's testimony and as we continue on then with the defendant's half of the case.